Hello, everyone. It is Tuesday, January 23rd, 2024, and this is your Crumbley trial update. Jennifer Crumbley wants the judge to order her son, Ethan, to testify at her trial, along with 3 psychiatrists that he spoke to following the deadly mass shooting he carried out at Oxford High School in November of 2021. This is according to a new filing. While waiting for jury selection to begin today, the filing shows that the mom got bad news at about 9:29 a.m. That is when her lawyer got an email from her son's lawyers, quote, confirming that the shooter will not waive any privilege or confidentiality. That means that he doesn't want any of his medical records used at his mom's trial on confidentiality grounds. That would mean that whatever Ethan Crumbley said to his psychiatrist is off limits. Though Jennifer Crumbley's lawyer has asked a judge to order the doctors to testify, maintaining her client will not get a fair trial without their testimony or the testimony of her son. Jennifer Crumbley is the first parent in America charged and tried in a mass school shooting. She and her husband, James, who goes on trial on March 5th, are charged with involuntary manslaughter for buying their son the gun he used in the shooting. And that shooting left 4 students dead and injured 6 others and a teacher. Oakland County Circuit Judge Cheryl Matthews said before the first set of 50 prospective jurors entered the room, quote, this trial is obviously very stressful for everyone involved. A pool of 300 prospective jurors was summoned for the historic case, with both sides hoping to whittle that number down to 12 jurors who will decide the case and 5 alternates. In the morning, a pool of more than 50 individuals entered the Oakland County courtroom at noon, heard jury instructions, and then took their oaths, promising to set aside any beliefs, emotions, or biases, and decide the case based on only the evidence presented at the trial. Matthews then excused everyone for a lunch break, then begged the jury pool not to discuss the case with anyone, and directed them towards the cafeteria. This is the moment that strikes fear in my heart. She asked them to pinky swear not to discuss the case, go on social media, or look at any media coverage of the case. We need your help. This is a big deal. It's important to both sides, she said. In the afternoon, the topic of guns heavily dominated the jury selection. Even though the judge stressed to the jurors, we are not here to decide if people should have guns. But after Matthews asked the pool if anyone had strong opinions about guns that she should know about, multiple hands went up. One woman said, I don't like guns, and we know the gun in this case wasn't secure. The judge responded, no, we don't know that. Still, the woman expressed concerns about a gun not being secured, stating, if someone got a hold of a gun, I wouldn't excuse that. The prospective juror was sent home. Another woman said, I don't believe in anyone having a gun at all. She was excused too. So was a man who said he didn't have a problem with people owning guns, noting his grown son who lives with him has one. But he raised concerns about whether the Oxford school shooting was preventable and how the teenage shooter got a hold of the gun, stating, it could have been easily avoided. The judge said, you don't know what happened. That's for you to decide. The judge also gave him an analogy to consider. If a son took his father's gun and shot someone with it, is it the dad's fault? The prospective juror concluded, the dad would bear responsibility if the child were a minor, stating, it's my job to protect him and others. He was dismissed. Parental responsibility was mentioned multiple times during jury selection, as the judge asked the prospective jurors to consider whether a parent is responsible for their child smashing a neighbor's window with a baseball. One man in the jury box said, comparing a baseball to a gun is a bad example. The panel of 17 individuals who were interviewed Tuesday included mostly parents, including one woman who said, I have a 10-year-old autistic son. When I think about this case, I feel rage. Still, she said she can be fair and impartial. At issue for the mom's defense lawyer is that her son's text messages to a friend and journal entries are going to be admitted. In those texts and in his journal, Ethan claimed that his parents ignored his pleas to get him help. for mental health issues, a theme the prosecution has been hammering home since the parents were arrested more than 2 years ago. The mom's lawyer, Shannon Smith, argues that the prosecution gets to admit those text messages and journal entries, then she should be allowed an opportunity to rebut them. To do that, she argues, she must question the shooter and his psychiatrist about statements he allegedly made that contradict his claims that his parents ignored his pleas for help. Shannon Smith wrote, quote, "The specific evidence would contradict claims in the text messages that have been deemed admissible between the shooter and his friend. The statements that have been deemed admissible in the journal and texts are tantamount to testimony by the shooter because they are being admitted as substantive evidence. As such, it is critical that defense counsel be able to impeach this critical evidence, or it simply cannot come in." She also stressed failure to impeach the evidence from the text messages and journal entries will deprive Jennifer Crumbley of her constitutional rights. Specifically, she will be deprived of a fair trial. In her filing, Shannon Smith also disclosed another development that caused her concern. On Monday, 2 lawyers from Easter Seals noted in a court filing they are representing the shooter's 2 jail psychiatrists in light of the subpoenas they received to testify. It is anticipated they will be raising issues as to privilege and asking this court to order whether or not the doctors can testify. The shooter's mental health is a crucial factor in Jennifer Crumbley's case, as the prosecution has long argued that both James and Jennifer ignored a troubled son who was depressed, lonely, and hallucinating. And instead of getting him help, they say they bought him a gun, which he used in the Oxford school shooting. And here is why Ethan Crumbley's testimony is crucial to both James and Jennifer's case. If he does not testify, the defense cannot question him about whether his parents influenced his decision to shoot up the school or played a role in the shooting, a topic he addressed at his sentencing last month, when he told the judge the following: "We are all here because of me today, because of what I chose to do. My parents did not know what I planned to do. They are not at fault." The mom's lawyer argues that the medical records should also help bolster that claim, and interviews he had with psychiatrists can show he is not reliable. According to courtroom testimony and court records, the shooter made potentially damning admissions to one psychiatrist by allegedly stating that he had never asked his parents for therapy, and admitted that he lied when he texted a friend about asking for such help. This information is clearly critical to the Crumbleys, who have been criticized repeatedly by the prosecution for not listening to the shooter's request for therapy. That is all in Shannon Smith's newest motion. The shooter, Ethan, who was 15 when he carried out this massacre, pleaded guilty to all his crimes and was sentenced to life without the possibility of parole last month. He is appealing that sentence. As jury selection concluded today, the jurors were asked to be back at 9 a.m. tomorrow, and hopefully we will have a jury seated by the end of the day Wednesday. We will keep our eye on this into the day tomorrow on Wednesday. Stay tuned and make sure you're subscribed for updates. See you guys in the next video. Be sure to check out my other videos and playlists for more true crime content. And if that's not enough, you can join our Patreon. Don't have a tinfoil hat? It's okay. We'll make you one. It's that easy. See you guys in the next video.
See you later. Bye.